First and foremost, I would like to thank the Madhyasthta team and the student members of Adv.Madhu Law College for inviting me to do a session on mediation. The topic for today's discussion is the impact of mediation on other business laws. So first let us see what is mediation and a brief note on the new Mediation Act 2023. As you all know, mediation is an informal process and it is a highly confidential and voluntary process. During the process of mediation, the mediator and the disputing parties will be present. And the presence of the parties' advocate or lawyers is optional and it is not a mandatory thing. The mediator during this proceedings will only facilitate and assist the parties to arrive at any amicable settlement. So during this process, if the parties are not willing to settle, they could walk out at any time and they could opt for any other adjudication forum to resolve their disputes. So what is this new Mediation Act 2023 speaks about? The major feature of this act is the enforceability of the mediation settlement agreement. So before the enactment of this new Mediation Act, the settlement agreement, whichever is arrived during this mediation proceeding, is not enforceable. It has to be either pronounced by a court or some other adjudication forum. But now, after the enactment of this new Mediation Act, the settlement agreement, whichever is arrived during this mediation proceeding, is enforceable and it is binding upon the parties. It is enforceable similar to the court pronounced judgment as under CPC. This act also speaks about the time frame for completion of mediation proceeding, which is 120 days. And this time period can be extended for another 60 days with the mutual consents of the parties. This act also emphasizes regarding the formation of Mediation Council of India. This Mediation Council of India will be accrediting the mediation service providers and the mediators, and they will be maintaining a panel of mediators. This new act also speaks about the online mediation, and it also briefs about the disputes that could not be settled under mediation. The disputes involving claims against minor children and intellectually disabled persons and criminal offences which are highly compoundable, and land acquisition matters and tax related matters and disputes regarding electricity, telecom, etc. that are not that could not be mediated as under this act. Okay, so let us see the stages of mediation proceeding. So once the parties are willing to settle, they will look for the options for mediators, and they will be selecting and appointing a mediator. So once the mediator is being intimated regarding their appointment, he will be sending a notice regarding his disclosure, that is his past relationship with the parties and the subject matter of dispute, etc. So upon receiving the notice from the mediator, the parties will be reviewing, and once the parties are okay with that mediator, the mediation proceeding will be commenced. So first there will be a joint sitting between the parties, among the parties and the mediator. During that joint sitting, the mediator will introduce about himself and ask the parties to introduce themselves. And there will be an opening statement during which the mediator will explain about the mediation proceedings and the features of the mediation. First, he will be saying that mediation is a voluntary process, that is, the parties could walk out at any time, and it is a highly confidential, that is, neither the parties or mediator should not disclose any of their discussions during this proceeding before any of the adjudication forums. And he will also say that this mediation proceeding does not limit or restrict the parties to go for any adjudication forum. So he will be explaining about all these things, and he will ask the parties to brief their conflict and disputes. So once the parties explains about the conflicts and disputes, he will try to understand and rephrase it. So this is what happens during the joint sitting, and after that, after getting proper consent, mutual consent from the parties, he will schedule for private sessions. And the Mediation Act or any of the act does not limit regarding the number of private sessions. So during the private sessions, the mediator will ask about the parties, and he will understand about the position, and will try to get to know about the interest of the parties to settle the this conflict. So during these joint and private session, if the mediator understands that this matter could be settled and the parties are showing their willingness to settle, then the mediation settlement agreement can be drafted, and it can be reviewed and finalized with the parties and the mediators. So after that, there will be a closing statement, and following which there will be a conclusion for the mediation proceedings. So this is a short brief of mediation proceedings. Okay, now let us go into the topic for discussion today. That is the impact of mediation on other business laws. Okay, I hope you had come across this Arbitration and Conciliation Act 1996. This act has a provision for conciliation proceedings. This conciliation proceeding is merely the same proceedings as of mediation. So before the enactment of Mediation Act 2023, there was a conciliation proceeding. Now it is replaced with mediation proceeding. So the conciliator is termed as the mediator under Arbitration and Conciliation Act. Okay. So next, let us have a look on Micro, Small, Medium Enterprises Development Act. Development Act 2006. This act was regulated by the central government mainly to benefit the micro, small, medium enterprises in India. So if there is any commercial disputes or delayed payment disputes between the supplier and the buyer, then the supplier can initiate a case before the Micro Small Facilitation Council. This Facilitation Council will be existing in every district of the country. So they could file a case before this Facilitation Council, and the Facilitation Council first they will initiate a conciliation proceeding. Actually earlier it was conciliation proceeding, but because of this new act it is termed as mediation proceeding. This Facilitation Council will either conduct the mediation either by themselves or refer the matter to any mediation center or mediation service providers. So if the parties are willing to settle, then mediation settlement agreement will be formalized. If not, the Facilitation Council will declare the mediation as failed and will escalate the matter to arbitration. So once a matter is escalated to arbitration, it will be conducted as per Arbitration and Conciliation Act 1996. Okay, next let us have a look on the Commercial Codes Act 2015. As the name states, this act deals with commercial matters and contractual disputes. This commercial codes exist in every district of the country, and upon the parties approaching this court, first there will be a mediation proceeding. Unless until the parties are looking for emergency or interim measures, it is mandatory for the parties to exhaust the pre-litigation proceedings before the case is being taken up by the court. So this pre-litigation mediation can go for about 120 days. Then it can be extended for another 60 days. And if not, if the parties are not willing to settle, then the court will take up the case and further adjudication proceedings will be happening. And now let us see about the Consumer Protection Act. Hope you had come across this act. It is a familiarized act, as you know. Unlike Commercial Codes Act, this act does not mandate the mediation proceeding. During the continuation of the adjudication process, the parties are willing to go for joint sitting for settlement. At the time, the court will refer the matter to the mediator, and the mediator will be conducting private and joint sessions. The matter could be settled, then the mediation settlement agreement can be formalized. If not, the mediator will submit a report before the court stating that mediation failed. One important thing is that the mediator in this report should not state about the reason for failure of the mediation, and you should not disclose about any of the discussion that happened during this mediation proceeding. With this we can see the confidentiality of this mediation proceeding. Okay, now let us see the importance of negotiation in mediation. So once the parties are willing to settle during the, joint and private sessions, the mediator will help the parties to generate options of their settlement, and so that the parties will list out their options and prioritize based on their interest, and with the brainstorming and negotiation sessions, they will somehow come to the settlement, and after that the settlement agreement will be drafted. So this is how the negotiation is helpful in helping the parties to settle the matter under mediation. So the mediation settlement agreement is one of the important thing, because this mediation settlement agreement mandates the parties' signature and the mediator's signature, and this mediation settlement agreement should be crisp on the terms of settlement. That is, when the matter, how it has to be settled, when it has to be settled, when the payment has to be made, where it has to be made, the mode of payment, everything has to be clear. The terms of settlement should be clear and definite. So this is how the mediation happens in India as well as all over the world. Hope the session is insightful and useful. Thank you. Thanks for the opportunity.